left off of the topicality argument that my partner ran in the last speech. Now, he'll be responding to all of the arguments here, but I'd like to point out that if the affirmative team's second mandate is extra topical or outside of the bounds of the resolution, then the penalty for that is that the affirmative team's second mandate should be stricken from the round, that it will not be implemented when you vote affirmative. Now, the impact of this, and the reason that this applies to whether this is a significant problem, is if that second mandate is no longer applicable, they are only dealing with federal drug courts with their first mandate. That means they have to show you federal numbers on how many drug offenders there are, how many drug offenders are eligible for this program, and how many drug offenders are actually going to be solved by this program. Those are the significant numbers. They have to show you that there's a significant problem in the current system in order for them to achieve a net benefit. And if that second mandate no longer applies, they have to show you specific to the federal system. Now that I've gotten that argument finished, I'd like to move on to the argument of whether this is actually going to solve the problem. And I'm going to start by looking at recidivism, because I believe that this is a big argument in today's round. And I have several arguments I'd like to make under this. The first is I want to look at the study that they quoted in their 1AC, and there's a lot of problems with this study and the credibility of this study. So the first thing I'd like to look at is that the affirmative study did not give you a lot of specifics. Specifically, they didn't tell you how many people were studied with this. They didn't tell you how long they tracked these offenders. Now, why do these things matter? They matter because if we don't know how many they tracked, they could have looked at 2 people and said that they just gave a percentage. They could have looked at only 2 drug offenders and said that they didn't recommit an offense, and so it's not significant. They need to show you specifically the methodology for that study, how the study actually worked. Now, the second thing that's important here is if we look at the part of the evidence that the affirmative team did not read in their first speech, it says this. It says, quote, that recidivism was typically measured by fewer rearrests for new offenses and technical violations. Now, what does this mean? It means that the study was measuring new offenses and technical violations. It was not looking at recidivism as a whole. It was not looking at whether they committed drug offenses. It was looking at whether they committed technical violations or other new offenses. And so this study was not even dealing with whether they committed drug offenses. So that's the second problem with that evidence. And so the impact of this is that not only can they not prove that they are reducing recidivism, they also have not proved that they're helping lives or stopping violent crime, because these are technical offenses. They're not violent crimes that they're talking about. And that was the impact they presented you in the 1AC, but they haven't proven to you that that is actually significant, that that impact is going to happen. Now, the next thing I'd like to make under the recidivism argument is I'd like to read you a piece of evidence from the same study, and it was talking about how half of the graduates that were looked at with this study were able to quit successfully. They weren't even real drug offenders. They were just dealing those drugs, but they weren't actually addicted to them. And so this success about them stopping drug abuse doesn't apply, because a lot of the people that they dealt with were not actually real drug offenders. Douglas Marlowe and David Fester, this is the exact same study they quoted in their 1AC. It says, quote, the results of this study suggest that approximately 1/3 of participants with 3 misdemeanor drug court programs may have had a relatively minimal drug use problems. This finding raises a question about how to interpret success rates for drug court programs. It is impossible, for example, it is possible, for example, that as many as 1/2 of the graduates were drug experimenters who are not predisposed to continue or escalate their drug use, end quote. What we can see is that at least 1/2 of the offenders that were measured in this study were not even addicted to drugs. So the fact that they didn't go back to drugs is not a significant advantage to their affirmative plan. Now, I'd like to move on to my second solvency point, my second point about whether they're solving the problems, and that is looking at the actual rate of success with the program. Now, when we look at drug courts, we can see that they have had huge failure rates. For example, the specific drug courts have had over 25% failure rates. This is very, very significant. When we look at this, my partner brought this evidence up in the last speech, but we can see that the failure rates are huge. Now, they came back and they said, well, success rates are also huge, but for every time you fail, you're going to have to be paying double for those offenders. For every time you fail, we're going to have more offenders on the street. We're going to have a bigger problem. So this is very significant. Now, I'd like to move on to the disadvantages that will happen if you pass their plan. And these disadvantages are very significant. Now, the first one is what I like to call a masking disadvantage, and that is that the affirmative team is really masking the problem. They're trying to solve the problem, but they haven't actually addressed the real problem, because drug courts, when we focus on drug courts, it's an obstacle to better programs that can help drug abuse more. The National Association of Criminal Defense Lawyers said in September response to the epidemic of drug-related criminal cases that clogged courts and prisons have in many places become an obstacle to making cost-efficient drug abuse therapy available to addicts and reducing criminal caseloads, end quote. What we can see is that what happens is when we focus on drug courts, this program is not really the best program available. We have this disadvantage where we're focusing on the wrong problem. We aren't able to focus on the real solution, the solution that can work better in the status quo. And then I'd like to read another piece of evidence talking about how drug courts actually reduce the resources for more effective alternatives. The Drug Policy Alliance said in 2011 that, quote, drug courts have flourished at the expense of support services that are more accessible and that are more effective at improving health and reducing crime. The focus on drug courts has distracted attention from the real systemic issues that drive the scale and cost of incarceration for drug law violations, primarily aggressive policing strategies and draconian sentencing laws. What we can see is that the problem is the sentencing laws and the solution is not going to be drug courts. When we focus on drug courts, we have this disadvantage of not allowing the real solution to be addressed. And then the second disadvantage I'd like to look at is that of due process and is actually the fairness within the court. Because when we look at the drug courts, we see that a lot of the rules for evidence and the rules within the drug courts are not actually within the bounds of the due process that is guaranteed in our Constitution. Brian Houston said in 2011 that, quote, the prevalent concern is that the defendant will not receive the same level of advocacy and due process in specialty courts, and thus the interest of the defendant is not fully represented. The adversarial approach requires an impartial tribunal, formal procedural rules, and opposing parties, and entails the three principles of advocacy: zeal, disinterestedness, and confidentiality. What we can see is that when we look at this, the drug courts are actually not really going to harm the due process rights because they don't have the same standards for due process. They don't have the same standards for lawyers. They don't have the same standards for all of these things. And what happens is, putting them into these specialty courts, we're not guaranteeing these defendants the same rights that they should be guaranteed under the U.S. Constitution. So when we look at this round, the affirmative says that they have to present you with net benefits. Now the resolution says that they have to give you a significant reform. They have not showed you, one, that there's a significant problem at the federal level. They have not showed you that their problem is the best solution, and there are significant negative consequences. We would ask you to vote negative.
Are the judges ready? And the timer? All right. Now, the first thing I'd like to talk about is you want us to bring up the methodology for how our study was done. Is that what you asked in the beginning of your speech?
Yes, we want specifics on how many they were dealing with, how long they tracked them, what offenses they were.
Now, are you aware that about the first 200 pages of that binder I gave you address that? Do you expect us to read that entire 200 pages over the course of our 8-minute speech?
No, we were asking.
Actually, 5 minutes.
No, we don't. You don't have to read the entire study, obviously. We were just asking for those specific numbers, just like what is the number of participants, how long were they tracked. Those are just numbers you could tell in like 30 seconds.
Now, you also said that some drug court offenders were low-level offenders, correct?
Correct.
Now, your statistics said about 1/3, correct?
It was talking about that specific study. It said 1/3 to 1/2. Yes.
All right. Now, did you respond to the fact that we said in our previous speech that we only quoted studies that this did not apply to?
We were quoting the study in your 1AC, actually.
I was talking
about the study in your 1AC.
Right, I was talking about the government accountability office study that we quoted in our most recent speech. Did you respond to the fact that they only quote studies that were done effectively?
My partner will be responding to that argument in the next speech.
All right. And you also said that drug court participants relinquish some of their due process rights.
Yes.
Now, which rights are they actually losing?
I didn't actually have time to read the evidence, but I believe it was talking about specifically the right to counsel, and it was talking about having an impartial judge and jury.
All right. Could I see that piece of evidence?
Absolutely. I did not read it in the round, but